Today the question to be solved relate to general defenses in tort. The question is, Norman and Mark went out for a social evening using Mark's car. They called at a public house, where they both consumed a large amount of drink. Mark then drove Norman home and, due to his intoxicated state, crashed the car into a lamp post. Norman, who was not wearing a seat belt, was thrown through the car windscreen and was severely injured. Rita, who witnessed the accident, went to help Norman and cut her hands badly in so doing. Now, you have to advise Norman and Rita of any rights that they might have against Mark. Would your advice differ if, rather than going out together, Norman had met Mark in the public house when Norman had had little to drink, but Mark was already intoxicated, and Norman had then accepted a lift? This question involves multiple parties. It is important to remember that you need to establish liability first before you can discuss any defenses, and therefore structure is critical. Hopefully the failure in wearing a seatbelt should have triggered your recall of contributory negligence from your learning. Note in this question there is a conditional circumstance attached, so ensure this is dealt with in your answer, as this will lose you credit needlessly. It is often best to compartmentalize this section and leave it to the end. The following points need to be discussed while answering this question. Firstly, we have to discuss the liability of Mark to Norman. In this regard we will see the defenses available to Mark, which includes a voluntary consideration of statute law and previous common law extirpe causa contributory negligence in accepting the lift, contributory negligence in not wearing a seat belt. Secondly, we have to see the liability of Mark to Rita, and then the defenses available to Mark against Rita voluntary contributory negligence. So here Norman must first show that Mark owes him a duty of care. In those situations in which a duty of care has previously been found to exist, there is no need to apply the modern formulation in Caparo Industries plc vs Stickman, 1990. In fact, a duty of care has been found to exist in a number of cases involving drivers and their passengers, for example, Nettleship vs Weston, 1971. But, even without knowledge of such cases, we could deduce the existence of a duty of care, as it is reasonably foreseeable that by driving carelessly, a passenger may suffer injury. Again, approach the duty of care situation pragmatically, and only develop the discussion at length if it is strictly necessary. Next, Norman must show that Mark was in breach of this duty, that a reasonably competent driver, in Mark's position, would not have acted in this way. See Blythe vs Birmingham Waterworks, 1856, Nettleship. It seems clear that a reasonably competent driver would not drink-drive given the risk of crashing, as was the case here. Mark is in obvious breach of his duty, not least as the behavior is criminal. Do not forget the logical structure of a claim in negligence. Once duty of care has been established, the question then turns on whether a breach of that duty can be established. Once that is done, then causation must be considered. Norman will also have to show that this breach caused his injuries, and the but-for test in Cork vs Kirby McLean, 1952, proves the required causal connection, as but for the drink driving and crash, he would not have caused Norman's injuries. Finally, Norman will have to prove that the damage that he has suffered was not too remote, that is, it must be reasonably foreseeable, as in the wagon mound, No. 1, 1961. This should not give rise to any problem, as all that Norman will have to show is that some personal injury was foreseeable, which is clearly the case with a passenger in Norman's position. He will not have to show that the extent was foreseeable, or the exact manner in which the injury was caused. See Smith vs Leachbrain, 1962, and also Hughes vs Lord Advocate, 19. The first possible defense, however volenti non fit injuria, that Norman voluntarily submitted or consented to the risk of injury. The law is now firmly established under Section 149(3) of the Road Traffic Act 1988, which rules out volenti in road traffic situations. For completeness of coverage, the answer considers the possibility of a volens defense. In the exam this would not be strictly compulsory, though demonstrating a flavor of the common law principles would impress upon the examiner the breadth of knowledge and impress, under the old common law, to establish that Norman was volens. Mark will have to show that Norman was able to choose freely whether to run the risk or not, and that there were no constraints acting on his freedom of choice, such as fear of loss of his employment. See Bowater vs Rowley Regis Corp., 1944. In the instant case, No such restraints were acting on Norman. The next point is whether there was any agreement between Mark and Norman, whereby Norman agreed to accept the risk of injury. There is no evidence on the facts that we are given to suggest such an agreement, so we need to consider whether there was an implied agreement. In cases involving persons who have accepted lifts from persons whom they know to be intoxicated, the courts are usually unwilling to find that the accepting the lift has impliedly agreed to waive his right to sue the intoxicated driver. See Dan vs. Hamilton, 1939. In Nettleship, Lord Denning stated that nothing short of an express or implied agreement would suffice to found a defense of volenti. However, this view has not been universally accepted. In Dan, the court held that volenti could apply to those situations in which the claimant come to a situation in which a danger has been created by the defendant's negligence, although, on the facts of Dan, it was held that volenti had not been made out. Also in Pitts vs. Hunt, 1990, and Morris vs. Murray, 1990, it was held that the defense could apply in appropriate circumstances to passengers who accepted lifts from drivers who were obviously highly intoxicated. This though remains an academic discussion as the defense. He may also attempt to raise the defense of extirpe causa non iteratio in that both he and Norman were jointly participating in an illegal activity, namely, driving a motor vehicle whilst under the influence of excess alcohol. Contrary to Section 4 of the Road Traffic Act 1988, this defense was upheld in National Coal Board v. England, 1954, and Ashton v. Turner, 1981, but there must be a causal connection between the criminal act and the damage that the claimant has suffered. See Delaney v. Pickett, 2011, and also Gray v. Thames Trains 2009. Indeed, the wider flexibility of extirpe causa is reflected in Lord Hoffman's reasoning in Gray, who argued the defense is more policy than principle. This is best reflected in Beldamu's approach in Pitts, who stated that it would be an affront to the public conscience to allow the claimant to succeed. However, in Tinsley v. Milligan, 1993, the House of Lords preferred a test of whether the claim is based directly on the illegal conduct, and this test has been used by the Court of Appeal in Valina v. Chief Constable of Greater Manchester, 2002. The law on illegality has recently been revisited by the Court of Appeal in Joyce v. O'Brien and Trace Co. Limited, 2013. Who stated that the defense and the causation threshold would be satisfied where the character of a joint criminal enterprise was such that it was foreseeable that a party could be subject to an increased risk of harm as a consequence of the crime. Active encouragement was not necessary. On the facts here, which are analogous but distinguishable from Pitts, there is no evidence of encouragement. However, it could be made out that it would be foreseeable by Norman given the co-drinking and then subsequent drive that increased risk of harm was self-evident, thus leading to a conclusion that the activity caused the damage. Thus the defense could apply. Mark has a final option to raise the defense of contributory negligence to reduce the damages that he will have to pay. Norman Section 1(1) of the Law Reform, Contributory Negligence, Act 90, by Section 1 subsection 1, where a person suffers damage as the result partly of his own fault and partly of the fault of any other person, his damages will be reduced by such an extent as the court thinks just and equitable, having regard to the first person's share in the responsibility for the damage. Mark will have to show that Norman was careless for his own safety by not showing reasonable prudence. See Davis v. Swan Motorco 1949, and also Jones v. Livox Quarries Limited, 1952. Norman has been careless in accepting a lift from a driver whom he knows to be intoxicated. See Owens v. Rimmel, 1977. Thus, any damages that Norman receives will be reduced due to this particular act of contributory negligence. In addition, as Norman was not wearing a seatbelt at the time of the crash, the extent of his injuries would have been reduced as he would not have been thrown through the windscreen. Norman's act has thus contributed to the extent of the damage he has suffered, and so his damages could be further reduced by up to 25%, as in Frum v. Butcher, 1975, in which it is emphasized that contributory negligence, unlike the other general defenses, is only a partial defense which, in effect, is to change the apportionment of his liability, as reflected through a reduction in their amount of damages that can be recovered. Turning now to Rita, she is a rescuer and can sue Mark, as in Haynes vs. Harwood, 1935. Mark will almost certainly be unsuccessful in attempting to raise the defense of Volenti against Rita, see Haynes vs. Harwood, 1935, and also in Chadwick vs. British Transport Commission, 1967. The only situation in which a rescuer will be held to be volens is where a rescue is attempted in circumstances in which there is no real danger, see Cutler vs. Diaries, 1933, which is not the case here. Mark may try to run the defense of contributory negligence against Rita in an attempt to reduce any damages payable to her, but the courts are reluctant to find rescuers guilty of contributory negligence. This has been done where the circumstances warrant it, as in Harrison vs. British Railways Board, 1981, but, in judging whether or not the rescuer has been careless for her own safety, the courts consider how the claimant may have been placed in an emergency. The court will be sympathetic to a claimant who makes a wrong decision in the agony of the moment, see Jones vs. Boyce, 1860-16, and more recently see Tolley vs. Carr, 2010. Thus, on the facts that we are given, it seems unlikely that a finding of contributory negligence would be made against Rita. If Norman had met Mark in the public house when Norman had very little to drink, but Mark was already intoxicated, then prima facie it would be easier for the court to find that Norman was volens to the risks of being a passenger in Mark's car. In Dan, it was said that if the drunkenness of the driver was extreme, the Volenti defense might apply. However, even if this were to apply to Mark, Section 149(3) would still render the defense invalid. On the basis of illegality, it is less clear, but it may appear more likely for the defense not to apply. The claimant's role in the enterprise of drink driving is far lessened such that it would now be less likely to pass the causation threshold, and therefore less foreseeable that such a risk of harm may occur as a result of the pursuit of the activities. Pitts-Joyce.